What is BC Assessment actually accusing Derek Holloway of? Have you ever read an actual court filing from a government institution suing one of its own retired employees? Because I have. And there are a few things in BC Assessment's notice of civil claim that I think every British Columbia should read for themselves. This is episode 2 of our ongoing series on the lawsuit BC Assessment has filed against retired senior appraiser Derek Holloway. If you haven't seen episode 1, I've linked to it on the screen and in the description. Today, we're going directly into BC Assessment's own filed court documents, specifically the notice of civil claim filed on November 20th, 2025 in the Vancouver Registry. Everything I'm going to discuss today comes from publicly available court documents. I also want to be clear that I'm not a lawyer and nothing in this video should be taken as legal advice. I'm approaching these documents as a member of the public, sharing my own observations and opinions about what I read. I encourage you to read the documents for yourself. They're available to download at overassess.ca. Let's start at the beginning, when the BC Assessment whistleblower said,
"Our CEO, he is, and trust me when I say this, he wants us to kneel to him. He thinks that he is our king. I am not kidding you. He wants us to swear allegiance to him, and I never signed a contract that says I can't go work somewhere else. But over the years, since he has been in power, I cannot have a second job with anything related to real estate. I can't get a job after I leave BC Assessment that uses inside information that I have for at least 1 year. I never signed these contracts, but BC Assessment, this is the sort of thing that he is doing. He realizes that people like me are frustrated. We are leaving and we are educating the public, and he is trying to scare people."
Now, you'll remember homeowner Andy Ross from the UBO Appeal Group talking about BC Assessment threatening the group of seniors with allegations of slander and asking the Property Assessment Appeal Board to censor them. I've linked to that video on the screen and in the description.
And the other part there is, how are they going to shut us down? Let's scare us off, let's threaten us, we were charged, we could be classed with defamation of character, slander, just for saying that we think that you're not dealing with this properly or whatever it is, and you should be doing your job, or right? This goes on and on.
So here we have a BC Assessment whistleblower saying the organization tries to scare employees who leave and educate the public, and we have homeowner Andy Ross describing what he believed was the same tactic being used against property owners. Whether you agree with those statements or not, I found it interesting that both describe what they perceived to be similar experiences from two different perspectives. Now let's fast forward to today. BC Assessment has filed a lawsuit against former employee Derek Holloway, alleging he used inside information after leaving the organization. What caught my attention, however, is something else. The very same Vancouver Island assessor involved in the UBO Appeal Group, who was alleged to have made those threats at the appeal board, retired from BC Assessment last year in June of 2025. That same month, they published on their LinkedIn that they started their own property assessment consulting company. That immediately raised a question in my mind. If BC Assessment says former employees should not be using their inside knowledge after they leave, then how does that fit with a senior assessor retiring and immediately entering the property assessment consulting business? And the more I looked into it, the more interesting it became. This isn't a small industry. property assessment appeals have become a significant business in British Columbia, and maybe one of the reasons the number of appeals at the Property Assessment Appeal Board has more than doubled over the past decade. Some of the largest firms in the world operate in this space. Ryan LLC, headquartered in Texas, is one of the largest property tax consulting firms in the world and has operations here in British Columbia. Over the years, it has acquired competitors throughout the industry. And in 2025, it completed the acquisition of Altus Group property tax business for approximately 700 million Canadian. I share this with you to magnify just how much money is at stake here. This is very much big business. The example I like to use is Chip Wilson, the founder of Lululemon, who recently won approximately $18 million reduction on what has been reported as the most expensive home in British Columbia. He hired Ryan LLC to obtain that reduction. The way the appeal industry generally works is that firms often charge a contingency fee of around 50% of the tax savings they achieve. So, using simple numbers to illustrate the point, if the original BC assessment value resulted in approximately $90,000 in additional property taxes to the city of Vancouver, and Ryan LLC charged approximately $40,000 for obtaining that reduction, the Wilsons still come out ahead because paying Ryan is cheaper than paying the city of Vancouver. The problem, in my opinion, is that they shouldn't have to pay Ryan $45,000 or the city of Vancouver $90,000 if the property was overassessed in the first place.
They are trying to avoid the picture being painted that they have a failed computer system that is over budget.
If the whistleblower is right, then I think that raises an obvious question. Why are assessments being produced that property owners later spend thousands of dollars challenging? Why is BC Assessment defending those values all the way through to written submissions only to lose at adjudication before the Property Assessment Appeal Board? Every time that happens, another written legal decision is created saying the assessment should have been lower. In my opinion, this creates a market where substantial fees can be earned correcting assessments that should arguably have been accurate in the first place. Think about it. Why pay the city of Vancouver when you can pay me? If I can convince you that your assessment is too high, save you $90,000 in taxes and charge you $45,000 for doing it, everybody wins except the taxpayer who should never have been put in that position to begin with. Now, I want to be clear. Ryan LLC isn't doing anything wrong. I do believe property assessment appeal firms provide legitimate services and that my commentary is about the system, not the integrity of any specific firm. Then, the next question I have is this. What happens to the $90,000? It doesn't simply disappear. Municipalities still have budgets to fund. So if one property pays less because its assessment is reduced, who makes up the difference? Is that cost redistributed across the remaining tax base? If so, that raises even bigger conversations about ultimately who bears the cost when assessments are wrong in the first place. That was the point where I started asking another question. Who are the people behind this industry? I was able to identify at least a dozen former BC assessment managers who have since gone to work for Ryan LLC. There may very well be more, but those are simply the ones I was able to identify. When you consider BC Assessment has approximately 200 employees, there are only so many management positions within that organization. Seeing at least a dozen former managers leave the same company starts to look like what many people would describe as a brain drain, where experienced professionals leave one organization and take decades of knowledge and expertise into another. What makes that even more interesting is that this relationship isn't new. For years, BC Assessment and Ryan LLC have partnered to present educational workshops for members of the Appraisal Institute of Canada's British Columbia chapter called Demystifying the BC Assessment Appeal Process. Then I noticed another interesting connection. Many of the BC Assessment employees I dealt with over the years earned their education through the Real Estate Institute of British Columbia. Today, the president of that institute is also the director of property tax at Ryan LLC. Looking back at the institute's past presidents, you'll also find the current CEO of BC Assessment. Now, I want to be clear, I'm not suggesting there's anything improper about any of these relationships. I think they demonstrate just how interconnected the property assessment profession is in British Columbia. People move between organizations, teach together, sit in leadership positions, and build careers throughout the same industry. Which brings me back to Derek Holloway. If former BC Assessment employees have been moving into the property assessment appeal industry for years, then what makes the allegations against Derek Holloway different? That is one of the questions we'll begin exploring as we go through BC Assessment's Notice of Civil Claim. BC Assessment filed this lawsuit against Derek Holloway alleging two things: breach of an employment contract and breach of confidence. Derek worked for BC Assessment for 28 years before retiring. The claim says he ultimately retained and used records belonging to BC Assessment for his own purposes. That's the overview. But when you read the actual paragraphs, some specific details stand out. Earlier in this series, you heard the BC Assessment whistleblower make an interesting statement. He said, "I never signed these contracts." That comment immediately caught my attention when I started reading BC Assessment's Notice of Civil Claim against Derek Holloway. BC Assessment's claim rests heavily on what it calls implied terms of Derek's employment contract. These are not the terms the Notice of Civil Claim says Derek signed. Instead, BC Assessment says these duties are implied by law as part of the employment relationship. They include things such as duty of loyalty, a duty to not retain employer property, and a duty to comply with company policies. At paragraph 7 of the Notice of Civil Claim, BC Assessment specifically says these implied terms arose, quote, as legal incidents of employment contracts generally, end quote. In other words, BC Assessment is not pointing to a specific contractual clause that Derek signed. It is saying these obligations exist because the law implies them into employment contracts. BC Assessment also relies on its standard of conduct policy, specifically the October 31st, 2014 version, which it says contains post-employment confidentiality obligations. I want you to remember those 2 points because they become important later in the series. First, BC Assessment relies on implied legal duties. Second, it relies on its standard of conduct policy. As we work through the evidence, we'll examine both in much great detail. Now, I want to stop at paragraph 15 of BC Assessment's claim, because I think this is the paragraph that most people will find most significant when they read it. Paragraph 15 says, and I'm reading directly from the filed document, that after Derek's employment ended, he continued to retain the records and use them for his own purposes, including, and these are BC Assessment's own words in their court filing, providing private consulting services and publicly criticizing BC Assessment, end quote. I want to let that sit for a moment. BC Assessment's own lawyers wrote those words into their own court filings. BC Assessment expressly alleges that Derek publicly criticized BC Assessment while also alleging he retained confidential records. That language is in paragraph 15 of the notice of civil claim filed by BC Assessment's outside counsel on November 20th, 2025. You can read it yourself. There's one more paragraph I want to highlight before we get into the specific incident BC Assessment relies on. Paragraph 13, it says again, BC Assessment's own words, BC Assessment does not know the full extent of the retained records at this time. The full extent of the retained records will be determined through discovery, end quote. Read that carefully. BC Assessments filed a Supreme Court lawsuit against the former employee, and in their own filing, they acknowledge they don't yet know what he actually retained. They are asking the court to order Derek to tell them what he has, so that they can determine whether he did anything wrong with it. I found that interesting. So, what is the concrete incident that triggered all of this? According to the BC Assessment Notice of Civil Claim, in September 2025, Derek sent an email to a former BC Assessment in-house lawyer. Attached to that email were documents that BC Assessment describes as privileged and confidential communications that Derek had retained from his time at BC Assessment. According to the claim, Derek referred to those documents as being in, quote, my files, end quote. BC Assessment then sent 2 demand letters. The first was dated October 1st, 2025. The second followed 17 days later on October 17th. That second letter warned Derek that if he did not respond by October 28th, BC Assessment would commence legal proceedings. According to BC Assessment, Derek did not return the records they requested. On November 20th, 2025, BC Assessment filed this lawsuit. So according to the Notice of Civil Claim, that's the sequence of events. 1 email, 2 demand letters, 1 lawsuit. Just 50 days from the first demand letter to filing a lawsuit. What struck me as interesting was how quickly the dispute escalated. I'll give you an example of a personal situation I found myself in. Last year, I found myself in a trademark dispute with Remax International out of Denver, Colorado. I call it the Red Topper case. Their lawyers, a big firm in Vancouver, similar to the one suing Derek Holloway, alleged that the red sold toppers that realtors put on top of their signs, well, when I was placing it on my real estate signs, they were too similar to Remax's color scheme of red over white over blue, and it would confuse consumers because they held trademark rights relating to their branding. I represented myself against a national law firm. Over the course of approximately a year, we exchanged correspondence, discussed the issues, and ultimately reached an agreement. I stopped using the red sold toppers and switched to the green ones instead. The matter was resolved without anyone filing a lawsuit. My point isn't that every legal dispute should take a year. Every case is different. My point is that in my experience, lawyers generally try to exhaust demand letters, negotiate a resolution, and mitigate the dispute before asking a court to become involved. So that naturally left me with another question. Why did BC Assessment move to a lawsuit against Derek Holloway so quickly? Now let's be clear. I'm not saying I know why BC Assessment made that decision. I wasn't in the room, and I don't know what discussions took place behind the scenes. What I am going to do throughout this series is share my observations based on my own experience. Derek Holloway wasn't just another former employee, he was writing publicly about the property assessment appeal system. His last published article on the City Watch website, "It's no joke when the system fails the mission, a personal journey at BC Assessment," was published on October 14th, 2025, right in the middle of this timeline. 3 days later, BC Assessment sent its second demand letter. Derek was given until October 28th to respond. Then on November 20th, BC Assessment filed this lawsuit. What happened next? Well, Derek disappeared from the public conversation. As of today, it has been more than 8 months since he's published that article, and I haven't found another one since. I can only speak from my own experience. Over the past 3 years, more than 30 newspaper articles have been written about my advocacy, and those articles have been syndicated more than 450 times across British Columbia media outlets. One thing I've learned is that the property assessments follow a very predictable annual cycle. Assessment notices are issued on January 1st, public interest spikes, homeowners begin asking questions, newspapers start covering assessments, letters to the editors appear, and property owners prepare review panel appeals. The entire conversation builds right through March 15th's appeal deadline. It's been happening for decades. So when I look at this timeline, what was the intention? In my opinion, BC Assessment moved very quickly, and the practical effect was that one of its most public former employees was no longer publicly commenting during the busiest assessment appeal season of the year. Again, was that the intention? I don't know. Was that the result? Looking at the timeline, that certainly is how it appears to me. As this series continues, we'll see why I think that distinction matters. But before we go, let's look at what BC Assessment actually wants from this lawsuit. They're asking the court for several things. First, an order requiring Derek to provide a complete inventory of every record he retained, file name, date obtained, how he got it, how long he kept it, where he kept it, why he kept it, who he shared it with, and how he deleted it. Second, an order requiring him to return all copies of the retained records. Third, damages for breach of contract and breach of confidence. And fourth, cost of legal action. Now here's what I want you to know about that list. BC Assessment is asking the court to order Derek to inventory records they've already acknowledged they don't know the extent of. And they're asking for damages for a breach of confidence claim where by their own admission in paragraph 13, they don't yet know what was actually retained or used. Meanwhile, former BC Assessment employees have been moving into the property assessment appeal industry for years. And BC Assessment itself has a long-standing professional relationship throughout that industry. Yet, Derek Holloway is the former employee facing this lawsuit. Since it was filed, I haven't been able to find another article published by him. Whether that is related to the lawsuit, I cannot know, and I'm not suggesting that it is. But when I consider that timeline, together with what appears to be a different standard being applied to Derek Holloway, I think it raises legitimate questions that deserve to be examined. While I researched this, I came across something else that caught my attention. Last year, I wrote the Minister of Finance asking about the independence of the Property Assessment Review Panel. In the minister's written response, I learned that approximately 10 panel members previously worked for BC Assessment. The province explained that the former BC Assessment employees are not considered for appointment until they have been away from the corporation for at least 2 years. And when appointed, they are assigned outside the regions that they were previously worked in to avoid conflicts of interest. I found that interesting because it demonstrates that former BC Assessment employees continue to play important roles throughout British Columbia's property assessment system, provide appropriate safeguards in place. That made me wonder why Derek Holloway's situation appears to be different. He's been retired for 9 years. I'm not suggesting the same situations are the same or that anyone acted improperly. I'm simply asking why one former employee became the subject of litigation while former BC Assessment employees continue to work throughout other parts of the assessment system under recognized conflicts of interest protection. 6 months later, Derek Holloway filed his response to civil claim in the Supreme Court, and in it he disputes and denies many of BC Assessment's allegations and provides his own explanation of what happened. In episode 3, we're going to walk through Derek's response using the same approach we use today by reading the filed court documents together so you can compare both sides for yourself. In the meantime, I'd encourage you to download the court documents at overassess.ca and read them for yourself. I think British Columbians are perfectly capable of reading the public record and coming to their own conclusion. If this story matters to you, please subscribe so you don't miss episode 3. Thank you for watching, and I'll see you in the next one.